Good afternoon, everyone who joined us today. Today we have an important topic in the context of reform and in the context of protection of human rights a year ago. According to Ukrainian legislation, State Bureau of Investigation should have started their work, but now a year passed and this bureau does not have heads of departments. It cannot carry out investigations, and we are speaking about grave violations, crimes. These are tortures and other serious violations of human rights by officials and law enforcement officers. So why this organization is not in operation and why it is important to start the work, and why without this body we won't be able to overcome torture. So our guests are Yevhen Krapivin, expert of Association of Ukrainian Monitors of Human Rights Conduct in Law, and Mykhailo Kamenev, expert of the Association of UMHRCLE and the Reanimation Package of Reform, and Alona Sotnik is absent today. So now I give the floor to my colleague, and he will tell us why a State Investigation Bureau is not in operation now and what prevents its activity. Good afternoon, everyone. Margarita said correctly that CIB should have been put into operation 1 year ago, but this story started long before. So when the Constitution of Ukraine was adopted, the prosecutor's office shouldn't have dealt with investigation, and now we are speaking about torture and mistreatment, and prosecutors' bodies carried out investigation, and this function should have gone to other body, and the question was to what body it should go. And in these 20 years, international experts, including ECHR, the decisions of which are obligatory for implementation, and also the court insisted that this should be competent, independent body of investigations, and in implementation of these decisions, part of them you see on the screen. In 2012, when Criminal Procedural Code was adopted, the start was given to the creation of State Bureau of Investigation. According to legislation, it should have been created during 5 years until November 2017. So prosecutor's office should have abandoned its investigation functions, and these functions should have been provided to the State Investigation Bureau because of inefficiency of prosecution of cases concerning torture. And a year passed, and SIB is not in operation, and prosecutor's office continues investigation of the crimes that it believes it is necessary to investigate. Article 36, the investigators continue their investigation according to Article 36 of Criminal Code. So the matter is personnel of SIB is in place, and investigators are in place, and when there is 1/3 of personnel is in place, and will be announcement about this, and in a week they plan to launch this body officially, so we are waiting. The matter is, there is an overall issue of efficiency because in today's model, they have broad jurisdiction. They can prosecute any subjects, not only officials, but also judges and officials, and even military crimes. And it turns out that if from the start in 2015, for example, the SIB should have concentrated on violent crimes committed in the course of actions of law enforcement bodies. These are torture or other violent crimes. In second reading, during voting, this jurisdiction was broadened, and now any crimes can be prosecuted by this bureau. So if the police officer got into traffic incident and some people were injured, or he committed domestic violence, or stole something, so it will be under jurisdiction of this bureau. And this body has 7 territorial offices and 1 office for 3 regions. So there is a matter of efficiency and sufficiency of means to persecute such crimes, investigate such crimes. At the end of our presentation, I will go back to the issue, how to overcome these problems, because now this bureau, they do not have proper understanding of matters concerning torture. This is not included in their strategic documents, and I've mentioned this, and I will mention this, that this can prevent the resolution of this issue, and we may face the situation then we will have anti-corruption bodies and as IB that will investigate some crimes, but torture won't be in the scope of action of this bureau, and we believe that in this way the impunity may continue and people will address to some international bodies in order to resolve these issues. So I would like to give the floor to Mykhailo Kamenev. The question is why this body that should become the body that would counteract torture, that it turned out in the body that will investigate all cases, and why we believe that it won't help us to overcome torture. Thank you for this question. As my colleague said, so these investigative functions were transferred from prosecutor's office, and this was envisaged by the Constitution of Ukraine in transition resolutions, and unfortunately legislators decided not to search for some ways, but just to provide all this jurisdiction to State Investigation Bureau. And here there is a problem whether this number of investigators be able to deal with such a big scope of cases in such a big territory. So these are big cases and minor cases involving police officers in traffic accidents and so on. So if these investigators are overloaded, maybe they will try just to deal with more prospect cases, for example, such as traffic accidents, because it is easier there to establish the guilt, so it is easier to investigate such cases for them. And in these cases, there is no big opposition of the system. And the issues of torture and abuse of power, the system opposes and tries to hide the facts. And it is often difficult to find proper evidence in such cases. So this issue concerning number and territory, this may be the major one. So the State Bureau of Investigation does not have a clear view of the problems, real problems of the Bureau, the number of people and so on and so forth. So they do not even try to carry out some research how it should work in the future and what they really need. It is important to do this because there is a budget process. It doesn't work today for tomorrow. And for example, we need not 1 but 3,000. Let's have them. So this will be for the next year, planning for the next year, if there is money for this. So they have a very broad jurisdiction, and there can be erosion of these functions. And this body, it should deal with the most important cases, top issues, but it may become it may have jurisdiction on all the cases, all officials, and this is not a good way for this bureau. Also, they should understand their own priorities, what they want, what they need to investigate, and what will be the main focus of their activity. So, how this body was put in place? We may see the criticism from the side of the experts, of civil society. So this body is formed, the commission was formed by the president, by the cabinet of ministers, by the parliament, but constitution does not envisage such functions of these bodies. But they decided to broaden them, and this will be one of the next questions in order that Constitutional Court would resolve this issue. Also, the president nominates the director, but this is the body of executive power. In Constitution, it is envisaged that the heads of executive bodies are nominated by, appointed by the Cabinet of Ministers. So the procedure was too politicized, and there is low trust from the public and the independent observers. It is not clear why Mr. Truba was appointed. So this process of selection was really doubtful. So the formation of the bureau is accompanied by the scandals and wars of compromise, and also closed ways to promote some people, ideas, or some actions. Roman Truba often makes steps that are not clear to nominate some people who were provided by the Commission, and he sends them to undergo lie detector. So this does not contribute to the trust of this body. Maybe he is right when he says that the selection by the Commission was made in the non-transparent way, but that should be, this proper explanations should be provided, and there should be proper legal grounds for this. If we consider the situation on the whole, there is doubt that the State Investigation Bureau will be really helpful in the matter of torture and inhumane treatment. So this was the issue before the Revolution of Dignity, and after Igor Indila was killed in Shevchenkovsky police department. After this, the issue of torture became really important and really interesting for the society and for the media. And the State Bureau investigation should become the body that will try to resolve this issue. But we should introduce many changes in order that the State Investigation Bureau would work in the right way. Before going to recommendations, it is important to say why we focus on torture. because this is one of the crimes that are in the criminal code, and we would like to explain how it differs from other crimes and why we want that the state investigation body focus its activity on crimes like this. And I would like to ask my colleagues to explain why we are not satisfied with the situation and why we are focused on torture. Thank you for this question, Margarita. So the matter is, so we need this body. It should be created because prosecutor's office cannot have investigative prosecutor's office and in other room procedural oversight officer because all non-objective investigations start from this, and in years it resulted in the situation, and I repeat this, at the international level they now recognize that investigation of torture it is not efficient now, and we may provide an example of 2017 when according to official data, more than 2,300 people addressed hospitals, and they said that they received bodily harm in the result of torture. And if we look at the number of cases registered and about the cases of suspicions, so these are non-comparable figures. Only 30 indictments are provided to courts on this. Only in 30 cases we have some real opportunity to bring officials to justice. Those who may, those cases may be suspended and so on and so forth. And in this situation, it turns out that all the system is built on principle of dependency, of some corporate solidarity, because despite the fact that prosecutors' bodies investigate torture, and you know that in police stations there's presence of torture, and the prosecutor's office, they do not have operative units, and these responsibilities are carried out by investigative units of national police. And in the result, we understand that these officers, they do not see any crimes, and they in all this, we have hope that SIB, being fully independent body, and it should be hierarchy. It should be independent from this hierarchy, and it should have its operative officers and investigators, and it will be able to influence the situation. And going back to the issue why torture is such a crime, with which we should first, why it should be priority. It is a negative thing that undermines the trust to law enforcement body, to law enforcement system, because unfortunately, despite all reforms and new procedural legislation, the system of investigation of criminal cases is based on forcing people to provide evidence first. There's a psychological pressure, and in case of need, they torture these people, and this has a systemic character, and investigations are built on this, and there's hope that the system of response will be created and that it will be efficient. And now we face the situation when more than 20 years passed since the adoption of constitution, but we are still at the same place, and in the context of prevention of torture or the work of preventive mechanisms or creation of some preventive mechanisms. So there is some progress, but in the context of response, if you look at criminal statistics, we understand that nothing is going on there. And also about the proposal, several words in this. There is a group of organizations that for many years dealt with the issues of fighting against torture, and they got united in the initiative of zero torture. And one of the tasks that this initiative has is to elaborate some comprehensive view, an analytical product on how to focus on the problems of torture and investigation of torture cases, to implement international recommendations that we have. And maybe possible decision of this analytical product. These are presented on the screen. So this broad responsibility should be, broad jurisdiction may be reduced because there is division between Article 127 and Article 365. Torture may be referred to the list of abuse of office, and this proposal is supported by the head of the consultative group at the State Bureau of Investigation, Mykhailo Kamenev. He is the known scientist. And also the problem that is interrelated, and that was mentioned many times, about 7 territorial units. Maybe it doesn't look like a problem, but we may bring a simple example. For example, if SIB have a territorial department in Mykhailo and in Khersonsk Oblast or in Kherson, an accident, traffic accident happens, then we understand that investigators of SIB will need several hours just to go there, to reach the place, and to get preliminary information together with the operative group. And also there is issues of exclusive jurisdiction and impossibility to use evidence that are provided in our own way. So there may be situation if preliminary actions are carried out by police, then some evidence will be rejected because of the violation of jurisdiction. So a lot of time is spent to carry out these criminal cases, and these issues of broad jurisdiction. So we should study the resources and how they should be implemented efficiently. So maybe some separate units may be created, and maybe more personnel should be involved, and separate units may be established to deal with torture, and units to cooperate with the Ministry of Justice and the Ministry of Healthcare, and also to develop some state policy in the sphere of prevention of and overcoming of torture. So we have anti-corruption strategy, anti-corruption policy, but unfortunately we forget about torture because the strategy in the sphere of human rights, the torture should have proper place, and the overcoming of torture should have proper place in the strategy. So SIB should have not only personnel but also technical resources and also some important skills. It turns out that there are no proper methodology how to record these torture, and they were not introduced in practice. So this is about Istanbul Protocol. In our state, they speak about this protocol a lot, but it is not implemented in law enforcement bodies' work. It turns out that training process for the investigators of SIB who will respond to torture cases, it is under big question, because those investigators who came from police, and we have a lot of people like this, they are aware of criminal investigation and economic investigation, but they do not know anything about investigation of torture and adjacent crimes, and we may face the situation that it will be not a priority for SIB, not because of bad will, but because there is no proper understanding how to do this and who will do this. So when this analytical project is ready, we are ready to present it and discuss it in the expert community and to represent it at public platforms. And now I just tried to outline the main points that may prevent the work of SIB as a competent, independent body of investigation of torture. And we really continue to wait for this body to come into operation. So, as we've heard, the SIB plans to be launched, and now there may be some problems in its activity, and these problems can be prevented at the start or at the first stage of its activity, because otherwise we may get the body that had a big mission but failed because of objective or subjective factors. If you have questions to speakers, please, you're welcome. Yevhen Vorobyov, Consultative Mission of the European Union. Yevgeny and Mykhailo, you said about change of and distribution of powers between investigative bodies. And what about interaction of SIB with other investigative and law enforcement bodies, with the national police, investigation department, and other bodies? And what are the priorities in the sphere of cooperation with other bodies and the issue of torture? Thank you for this question. First of all, we should look at what investigative bodies we have now and what will happen with them in the future. Police will remain the investigative body as bureau according to the law on national security of Ukraine, should become the body without investigative functions. This should be intelligence and counterintelligence. So this jurisdiction will go to the bureau or to police. So this will happen in several years, and then there is NABU, and its jurisdiction is clear, and it won't overlap with the State Bureau investigation, the State Investigation Bureau functions. And about internal security and so there were some abuse cases, and the prosecutor's office didn't want to investigate and provided it to internal security or to other units, and they carried out their formal investigations. Results were negative, and prosecutor's office just closed these cases and didn't make any action. So this will be a serious problem if SIB would rely fully on the internal security department of of police. I believe that, of course, they have professionals, but we should understand that internal security, it should not overlap these functions of external body. They should not replace one another. If internal security, they should do their work, they should have proper cooperation, and they should have confidential channels to communicate with proper bodies. And I believe that something should be done with executive investigative structures of profits and taxes. In the code we have it, but tax police was liquidated, so this issue needs a resolution. I don't think that it should be National Bureau of Financial Security that is promoted by Ms. Yuzhanina, but in any case, we should search for the ways and models how it can be done. So about the investigators of the penitentiary system, I would say that this is not constitutional. Speaking globally, for me, this is a great issue. Military crimes, how they will interact with the military law enforcement. But that is not the topic of this briefing. There should be some new pilot projects to establish some confidential channels of information, ways of informing this body. And there is a, that the Bureau, together with the Healthcare Ministry, they develop the instruction how to respond in case people address medical institutions when people declare that they were subjected to torture. And now doctors record this bodily harm, and these doctors, they should inform police on these cases. So people came from this police department, and the doctor should report to the same department about this case. So if we look systemically at the problems we have, so there may be many projects like this. So I personally do not have a ready-made answer. We should think the situation through. And this example about small guide, this is more revolutionary than everything that was done before in the sphere of response to torture, because this is the issue that is really of concern. So you said several times the word non-constitutional. Did someone audit the documents, and what lacks? What laws are lacking in order to have proper comprehensive approach to investigation concerning the issues of torture? First, about the first question, I would like to say that non-constitutionality of broadening of the responsibilities of President and the Parliament, this issue was addressed by Constitutional Court of Ukraine, and this position is stable. It has several tens of years of practice. So we may say that the broadening of responsibilities of the President or the Parliament by adopting the law, this is not constitutional. So these articles, two articles of Constitution that establish the responsibility of President and Parliament. So everything else is usurpation of power by one institution or one person. So this issue also increased during the Revolution of Dignity. And why it happened so? Maybe because of lack of agreement between different political groups. But now many bodies are being created, and they have this problem in them. So this is SEPO and the regulator and investigative State Investigation Bureau, and this list may continue. So this issue should be resolved because we are all interested in constitutional formation of the state bodies, especially bodies of criminal justice, and the deputies do not want to introduce proper constitutional propositions because they fear that in this way NABU may be ruined. This is Pandora box, but it is already open because Constitutional Court for 2 years it reviews the case about non-constitutionality of the decisions of the president concerning the regulator. So maybe it so about the changes. So there is draft law 5395D that may resolve these problems. Now there is no opportunity to get this operative units, and now it is impossible to bring someone to disciplinary responsibility if these people do not work properly. So no one knows who should punish these people. So these are the problems that are discussed on our website, but there are global issues that are still not resolved. For example, removal of external commission from the competition, because it raised many issues about the objectivity of the candidates, and also the about the issue of wiretapping. So they should refer to SBU to have possibility to record those illegal actions. So we hope that at least one draft law will be adopted to get this more operative units, because now this body became the hostage of some political miscoordination and political battles. And even this technical draft law is not adopted, but without the adoption of these documents, this body won't operate properly. So this is the end of press conference. If you'd like to speak with the speakers, please, you can do it off records. Thank you.